This week on Lewis on the Law, I have another great show for you. I have attorney Kevin Coleman in with me, and we're going to talk mergers and acquisitions.
Welcome to Lewis on the Law.
You are listening to Lewis on the Law. My name is James Lewis, and I'm your host this week and every week, and I have yet another awesome, empowering, and powerful show for you. I have attorney Kevin Coleman on with me, and he's an associate in corporate practice and banking at Troutman Sanders. Kevin, welcome to the show.
Thanks, James. I'm happy to be here. And I'm really here to kind of demystify some of what corporate attorneys do, and I'm just happy to be here, and I'm looking forward to the conversation.
That's right, because we're talking a big subject here, or at least it sounds huge, mergers and acquisitions. And I'm trying not to slip into that line from American Psycho. I won't even mention it, but it sounds like a huge topic. People are intimidated when they hear it, so you're going to demystify it, huh?
Yeah, that's right. It's, the name sounds fancier than it is. At its core, we're talking about buying and selling businesses. And, a lot of people don't understand exactly what we do and what M&A is. And I think we'll be able to just break down some of the basic building blocks of M&A, make it a lot more palatable.
That sounds awesome. And that's really what we're focused on. I know we have a lot of small business and medium-sized business owners on here. So hopefully they'll get something very beneficial out of this.
Yeah, I hope so.
It's all about empowering people. Okay. And once again, this show only provides information. If you have a serious legal issue, go ahead and contract with an attorney. If you're trying to merge or acquire a business, call Kevin. He'll get you through the ropes. Kevin, do you want to give them some contact information for you?
Sure. Again, I'm at Troutman Sanders, LLP. We're here in Atlanta, Georgia. My email address is kevin.coleman@troutman.com. And my direct number is 404-885-3436.
Okay, so mergers and acquisitions. What are we talking when we say mergers and acquisitions?
Well, the term merger and the term acquisitions, they're used and uttered in the same breath, but they're not exactly the same thing.
So a merger is not an acquisition?
A merger could be an acquisition. Okay. I know I said I was going to make this thing easier, and I just made it more difficult.
We're starting to get complicated already.
Yeah, we'll get into that. But just the basics of it. A merger is exactly what it sounds like. It's two companies coming together. If you have company A and company B and they merge together, then at the end of the day, there'll only be one surviving entity. So you go from 2 to 1. In a true acquisition, again, it's exactly what it sounds like. Company A buys company B. Well, company B still exists. It's just owned by company A now. So as far as the nomenclature, those are the two terms that we throw around. But again, we'll get into the different ways that those different transactions can play out. We'll get into that a little bit more as we go along.
Okay, so are there attorneys that specialize in just the mergers and then just the acquisitions, or is it just all in one ball game?
Well, in our practice, I can't speak for everyone's practice, but at Troutman Sanders, we handle it all. We do M&A because you never really know exactly
how it's going to go.
Yeah, how a transaction will play out. You may contemplate an acquisition or contemplate a merger, but there are a lot of considerations, and you decide based on a number of factors. It could be tax driven. It could be for different commercial reasons. So there are a number of reasons that I would doubt that someone would limit their practice in that way. Okay. It's more likely that they're equipped to do mergers and acquisitions and kind of the whole nine.
Okay, so are there different types of transactions, and can these be structured in different ways?
Yeah, absolutely. There are three principal ways that an acquisition, and I'll throw out the term acquisition more than merger throughout this talk, just for simplicity. But there are three basic structures for a transaction. There's an equity sale. And equity sale is probably what most people think of when they think about buying or selling a business. So an equity sale, if it's a stock company or if it's a corporation, then it's the shareholders selling their stock. If it's an LLC, then it's the LLC members selling their equity. So if James owned James LLC and you were the 100% owner of that company.
I just happen to own James Lewis Legal LLC, and I just happen to be 100. You did your homework, didn't you?
Well, I don't know. I think I just got lucky. But, so say you own that company, and let's just say you're not a practicing lawyer. Say you make widgets, right? I wanted to buy your company and own your company, and I wanted to purchase the equity from you. Well, what I would do is I would buy your interest in James Lewis Legal LLC. And
James Lewis Widget LLC.
Widget LLC. And at that point, the company doesn't change. The widgets that you were making stay the same. The only thing that changed is the change in ownership. The top level shareholder, it will be analogous to a shareholder in this situation. That's the only thing that changed. And then on the flip side, you have asset purchases where we'll take the same example, selling widgets, and I decided, you know what? I don't want to operate as James Lewis Widgets. I want to operate under the company I already have. Why don't I just buy all of his widgets from him and sell them under my name? So I have Kevin's widgets. I think my brand name is bigger. I think I have a bigger commercial footprint. I just need your product line. It complements mine. So I would approach you and say, hey, I don't want to buy your business. I want to buy your widgets. Sell me all or substantially all of your widgets. And after that, I will own the widgets. You will discontinue what you're doing because I'll pay you handsomely for it. And I will continue on with your product line. And then there's mergers. And again, we discussed that. It's exactly what it sounds like. Two companies coming together. Typically, they're acquisitions. So if I wanted Kevin's widgets, wanted to acquire James's widgets, we could structure it as a merger where your company merges into mine, and then your company ceases to exist after that. It's all Kevin's widgets after that. So there's some more complicated merger structures than that, but just at its heart, in essence, that's what we're talking about.
Okay, so you hear this term in the news a lot on Bloomberg. I watch Bloomberg surveillance, but you hear this, this distinction between public and private companies. So does that play into this? And what is public and private companies?
So it does play into it. And this conversation will be mostly about private companies. Okay. I think it's hard to squeeze public and private company M&A into one discussion, but just the high level overview, a public company is a company whose securities are registered on a public exchange. Like you hear about NASDAQ and the New York Stock Exchange. So let's use Coca-Cola as an example, right? So you could go and buy Coke tomorrow through your broker, and you could hold shares. Now it may be 1/1,000,000th of a piece of Coke, but you still own Coke. You own stock in Coke. And so the acquisition there would look different because I couldn't approach just you and say, let me buy all of Coke. I could buy your slither of Coke, right? But I couldn't buy all of Coke from you because it's fractured into 1,000,000 pieces. Versus a private company, you may own all of it, or it may be closely held and owned by 5 people, 10 people. So the considerations are different. And for that reason, a lot of public company acquisitions are structured as mergers because you don't have to go out and get everyone's consent for them to sell the company. You can make them merge if you get 50 in most states, 51% of the people to say, yeah, I'm okay with that. I'll sign on to that. And then you don't have to worry about getting the other 49%. If you get 51% of the people to say, sure, I think a merger is worth my money and I think it would be a value add to me, then you can merge the two companies. So there are some different considerations, but by and large, this discussion will focus on private company acquisitions.
Okay, so private companies, what are they? They're just 100% held or maybe partnerships or smally held?
That's right, yeah. A private company is any business entity that is not their securities are not publicly registered and publicly traded. Okay. So
it's just anything that's not. Okay.
Right. I mean, the vast majority of companies that you would think about as far as small businesses are private companies. So again, James's Widgets, if I started a law firm tomorrow, that would be a private company. And there are a ton of large private companies as well. So just because a company is huge doesn't mean it has to be public. It can stay closely held. A company that comes to mind is Enterprise Rent-A-Car. I know Enterprise Rent-A-Car, just from knowing folks who've worked there, they're huge. They're a billion-dollar enterprise, but it's family-owned. So that's a privately held company, even though their assets could rival those of some public companies. So they just chose not to go to the public market to raise money. So all of their ownership are just privately held.
And do the private companies, do they have a little more control? Is that why they don't go the public route? Oh, especially with a big company like Enterprise, is it because that they maintain a certain level of control?
Well, there's a number of reasons, but control is one of the reasons. Sometimes companies go to the public markets to raise capital, but there are a number of different reasons that a company would want to stay private or want to go public. Control is certainly one of them. I'm sure you've heard, and an example does not come to mind right now, but there have been public companies where It's been founded by one person. It started off as private. They've gone public, and a number of years later, they've been ousted because they don't own all of the company anymore. And either they've been ousted as a board member or a CEO, and so control is
like a
certainly
Steve Jobs thing that happened to him.
He
founded the company. Him and what's his name?
I forget the other gentleman's name, and I think it happened. I think it happened with
Wozniak.
Wozniak,
Right.
And I think it also happened with the Men's Warehouse.
Really?
Owner. I believe it happened
the guy
with
with
them
the
as
great
well.
beard.
I think
Who
so.
used to come on and
Who
tell
had
us
the
how
That's
great
right.
you'd look.
That's right. So yeah, control is certainly an issue, but there are a number of reasons. Again, that's probably outside the scope of this discussion, but a good point. There are a number of reasons as to why a company would remain private or choose to go public.
Okay, sounds good. Kevin, we're at the end of this segment, so why don't you give them some contact information for you again?
Again, I'm Kevin Coleman. I'm an associate at Troutman Sanders LLP. I can be reached via email at kevin.coleman@troutman.com, and my phone number is 404-885-3436.
We have another great show going for you today, filled with information that will empower you, the business owner. When we get back, we're going to talk timeline and milestones. I've got a lot of stuff. All my shows are archived on my website. Go to it, jameslewislegal.com. You are listening to Lewis on the Law. My name is James Lewis, and I'm your host this week and every week. And I have yet another awesome show for you. Thank you. I have attorney Kevin Coleman on with me, and Kevin works as an associate with Troutman Sanders. I'll add the last name. I probably shouldn't have. I don't know. But anyways, we're not going to get into that. We'll let him define all of that. Kevin, we're talking mergers and acquisitions today. Are there any things that we need to consider before we get into the deal? Because I mean, it's a big deal.
Yeah, there are a lot of considerations for a business, especially a business that's never been through this type of process. You know, if you've gotten to the point where you have created value in your company and you're looking to sell, cash out, exit, you know, every entrepreneur's dream. Well, there's
cash out for millions and buy that island in the Bahamas.
You know, that's the reality for a lot of folks. Not me.
You know, I've been watching a lot of Caribbean Life, and I'm like, yeah, St. Thomas sounds awesome.
And so these companies, they really need to prepare themselves for a process. So we'll talk about this from the target's perspective. If you're looking to sell your company, you know, there's a lot of housekeeping that you have to do. You want to make sure, well, because I'll take a step back. You have to realize that whoever's going to buy you or acquire you or merge with you or what have you, they are going to do a lot of due diligence on you. They want to know that you are who you say you are. There are no hidden liabilities, that your strengths are really your strengths, that they know your weaknesses, that they know what opportunities that you guys have that are, you know, valuable to them. So, you know, there's a lot of internal housekeeping. So, for example, I'll give you an example. You know, if you're a small business, you know, you and your brother and your sister run a business, there's probably not a lot of formalities being observed, right? You all know each other, everything runs smoothly. When a company comes in to buy you for, let's say, $20 million, they're going to want to know that you observe those formalities, right? So if you're ever thinking about being
before
bought
they
out,
buy themselves $20 million worth of lawsuit,
right?
Or federal violations,
or perhaps there have been some, there's been sloppy bookkeeping, right? And they can't properly evaluate your financials as they are. So there's some additional work that needs to be done there. You know, so I think the first thing to do if you're looking to be acquired is to put together your team of advisors, you know, your legal team, your accountants, the people who can help you actually prepare for the process. So there are a number of pre-deal considerations.
Okay, so does that go also for the purchaser too?
Well, it does, but it's not the same type of preparation. You know, a purchaser, and it depends on the method that they're going into the market to purchase. The purchasers are really, I think their first step is identifying what type of business or what type of entity or acquisition makes sense for them. You know, does this make good business sense? Will this add value for us? Will this add value for our shareholders? So their preparation is more along the lines of, you know, what does a strategic transaction bring to us and for us versus the target is really preparing to make itself enticing, right?
Yeah, right.
To a suitor. So their preparation, there's a lot of preparation on both sides, no doubt, but the preparation is different depending on which party you represent and which party you are.
Okay, so let's get back to the target here. How do they go? How do they go about actually getting it out that they are in the market to be bought?
So it really depends. Again, we can't cover all of our bases on this call or during this interview, but there are a few different ways. There is a negotiated process where perhaps there are a few potential acquirers that they've been talking to. Perhaps they all run in the same industry, right? So if James's widgets, to go back to our example, if those widgets are, let's call it the electronics industry, perhaps you're at all the trade shows with all the other electronics guys, right? Perhaps that's the circle that you run with, and maybe over dinner, maybe at a conference, you guys have started talks with another business. Say, hey, we've been pretty successful lately, and I know you guys have been looking to grow. Have you ever considered an acquisition? And perhaps it's organic like that. So that's probably the most basic level of how a company could market itself. Okay. Then the most extreme level would be a bid process.
Oh, wow. Like a public auction?
We would call it a private auction. Again, we want to focus this more on the private company sector. But, a company could hire an investment banker whose job is to market the company. And they may go out and they may identify 25 or more bidders that they know are interested in this space. And they would, and again, we're kind of short circuiting and simplifying the process, but they will go out to those bidders and share certain limited information and see if those bidders are interested in a potential acquisition. And then throughout a very structured process, they would narrow it down to a handful of bidders, and in connection with the purchase agreement and how that may look and the economics, if those look good, they'll actually decide on who they want to buy them. So you think about typically when someone's buying something, think about you buying a car, you typically have all the leverage because you have the money. The auction kind of turns that on its head, right? If you have 25 different people bidding on you, then you can increase your value for you and your shareholders.
Okay, so you hear this phrase all the time, and I this may be beyond the scope of this interview, but you hear this phrase hostile takeover. What is that about?
So again, that's more in the public company setting. And I'll give you just one brief example. You've probably heard of a tender offer. So we'll use Coca-Cola again, and their shareholders are public. So, you couldn't go to just one shareholder and say, sell me your shares and own the company. You need all of the shares. So, one method of a hostile takeover is a company bypassing Coca-Cola's board and offering all of the shareholders of Coca-Cola a premium of what their stock is worth. If their stock is worth $32 a share today, they may offer $37 a share, and that may be very enticing.
Ka-ching.
Right. And if all of those shares, and again, this is a simplified version, if all of those shareholders decided, that's a pretty good value.
Yeah, right.
I think we'll do that. And they get a certain number of them to agree. Then that's one of the,
shift the balance of power.
One of the typical ways you'll see a kind of a hostile takeover. And hostile just means the board didn't approve it. This didn't come from an internal process. Coke didn't say, you know what, we're in the market, we're going to sell off our, this division, or we're going to sell off Coke. Someone from the outside said, you know what, we're going to bypass the board and we're going directly for their shareholders. Let's see if they'll bite at this apple that I'm dangling. So.
Okay, so we'll get back into the private companies. So is there a process in which a business can go ahead and say, I'm interested in buying you? I mean, I know in real estate purchases, you do a letter of intent. Is there a correlation there? Yeah,
absolutely. It's not the first step. Typically, the first step would be a confidentiality agreement as the parties are sharing information about each other, to even decide if they want to pursue a transaction. But after they've decided that they wanted to pursue a transaction and the parties have been narrowed down and there are two that are emerging, then they typically would enter into a letter of intent. And in the corporate and M&A context, that's a non-binding, for the most part. There's certain provisions that could be binding, but it's an agreement to negotiate in good faith.
Yeah.
They may lock down the material terms, so purchase price and certain employment agreements. We would like to retain this person even though we're buying you. This person may need to retire. So they'll come to an agreement in principle, and then they will have to spend the next several months probably negotiating the actual acquisition documents, and they have agreed to do that in good faith, and that's what a letter of intent is.
Okay, so does this go into the business and legal due diligence process?
So that kicks it off, right? So you sign the letter of intent, And now the buyer is thinking, okay, let's get into this. And they would have done some diligence on the front end to even get to the letter of intent. But
it seems like that happens in the pre-buy consideration.
Well, there, in some processes they step up the amount of information that's available. So there may be a first round of negotiations, and they allow the buyer to see this much information, and then they may enter into a second round of negotiations, and they let them see even more information. But due diligence is just a fancy name for, am I stepping on a landmine? Right.
Right.
So, we'll use our time to talk about legal due diligence, and we'll continue on with this example of James's widgets.
Okay,
right. So let's say James owns.
I need to get into the widget business.
I guess so, man.
I can sell it for a couple
guess
million.
So
buy that island in the Bahamas.
So let's say James, let's say your company owns a huge manufacturing facility up in Buckhead, right? And I am going to acquire you. And let's just say I'm going to acquire all of your equity interests. So I'm going to buy your equity in your LLC. Well, there are a lot of things I need to start thinking about, right? The first that comes to mind, well, he has this big manufacturing facility. Is he dumping any wastewater or anything out the back door that I need to know about, right? And these widgets, does he own them? Does he license them? Who actually owns the intellectual property there? The real estate, does he own that building? Does he lease it? Would the landlord agree to us taking it over? There are a lot of different things. And, let's go to the plus side of the ledger, your contracts, your customers. You say you have $10 million worth of sales each year. Well, I'm going through your contracts to see, one, does that make sense? Does it all add up? Are there any pitfalls in these contracts that I need to know about? Are there any automatic triggers? That you may have entered into some deal that says, we'll pay you $1 million a year, but if you ever sell, you owe us $2 million, right? So you just never know until you get into it. So that's the nature of legal due diligence. We really want to find out if there are any landmines and whose risk, how is the allocation of risk going to play out here, and what do we need to know about that we need to protect ourselves from?
Gotcha. So, Kevin, we're almost at the end of this segment. Tell me a little bit about your practice again.
So my practice is corporate and financial institutions. And I would say a good bit of my work is M&A, but we also do a lot of general corporate work. So that could be restructurings, that could be general corporate governance advice. And we also counsel financial institutions, so fintech companies, community banks, large public banks. And so anything transactional or business transactions based, we can do it, and that's what we do.
You're listening to Lewis on the Law. We are at the end of this segment. I'm having a great time. This is an awesome show filled with information. All my shows are archived on my website. Go to jameslewislegal.com, and you can always email me at james@jameslewislegal.com. I have a podcast page. Our podcasts are international now. I've just heard we have people downloading podcasts in Sweden and Norway and all those fancy countries that I may get to someday. I've been to a couple of them, but not.
If you sell your widgets.
That's right. If I get into the widget selling business, then I might be able to do it. When we get back, we're going to talk about negotiating the transaction documents. You are listening to Lewis on the Law. My name is James Lewis, and I am your host this week and every week. And I have a great show going on with me. I have attorney Kevin Coleman on with me, and I have a great show going on with me. Sometimes this stuff just does not come out all right. But anyways, we're throwing a lot of information out to you guys, and I want to remind you that this show is only intended to empower you, the listener, with legal information. If you have a serious legal issue, you need to go ahead and contract with an attorney. You can find attorneys on my site. You can go ahead and go through my videos, my my podcast, and I allow all the attorneys to give you some contact information. So if you have an issue that falls into one of these programs, and eventually every single legal issue you can think of will be archived on my website. That's the grand goal. It may take a while to get there because there's a lot of legal issues, but go to my website, jameslewislegal.com, and just go scroll through the podcast, and you'll be able to find an attorney. You can always contact me, and if I can't help you with your legal issue, I can direct you towards an attorney that can. You can contact me at 404-610-0075. Once again, that's 404-610-0075. Or you can email me at james@jameslewislegal.com. Kevin, when we were just leaving off, we were about to get into negotiating the transaction documents. So let's get into that.
Okay. So, the first step would be, what type of transaction document do we have? We talked
Right?
about that,
Yeah,
it's
different
maybe a good time for kind of a recap. So we talked about mergers and two companies combining. We talked about equity purchases, where I'm buying all of your interest in a company. We also talked about asset purchases, where I'm buying your widgets directly from you, and your contracts and other assets as well. So, those are the three primary types of acquisition agreements. So we could have a merger agreement, we could have a stock purchase agreement, we could have an LLC interest purchase agreement, we could have an asset purchase agreement. So now many of the mechanics of these agreements are the same, but they do differ in some material ways, and that's probably outside the scope of this talk. We'll talk more about how they are consistent and what things are typically in all of these types of contracts.
Yeah, that makes sense. So what types of things are consistent in all these types of contracts?
So, and I got my little cheat sheet here to make sure I don't miss anything that's important. So, some of the basic elements of a M&A purchase contract, you start with the purchase price and purchase price adjustments as well. And we'll get into that in a little more detail in a little bit. You also have representations and warranties. You want the target, as a buyer, you want the target to make certain statements and disclosures for you. I promise you that I own all of these things that I say I own. Right. And if I don't own them like I say I do, then you have some recourse against me. Then there's also covenants. There are things that you cannot do while waiting to close the agreement. There also may be some covenants imposed post-closing. There are also conditions to almost every M&A contract, conditions to closing. You said that all these customers would come with us if we signed. And so we need their consent, and we need you to deliver that to us, because that's a big part of the value of us moving forward here. So you can have a number of conditions. There are termination provisions. If we get this signed up, in between signing and closing, who has a right to terminate this agreement and for what reason? Then there's indemnification provisions that just say, okay, you promised me you had all of these widgets and you owned them. Now you don't. This is the scope of how I can be compensated for your breach of that promise. So those are some of the common building blocks of a purchase agreement. And depending on your specific transaction, there could be different sections, but typically you'll find those sections in almost every purchase agreement.
Okay, so I think we've covered a lot of that. Can you get a little bit into the warranties that you might see?
Sure. So, I think we've already previewed that a little bit already. And we mentioned the due diligence, and it really dovetails nicely with the conversation on due diligence. So let's use our example with your big warehouse or big manufacturing facility that's out in Buckhead. So if I were a buyer, I would have you rep that you have not had any environmental spills, any environmental problems, that you own your real estate, or at the very least you lease it and you have the right to lease it and have the right to operate it. I would want to know that you own your intellectual property, so I would make you affirm that. And really all this exercise it's a disclosure and risk allocation exercise. If you do have environmental spills from 5 years ago and I buy the company from you today, and then the EPA comes after me a year from now and say I owe them $10 million for something that happened 5 years ago. Well, who pays for that? Right? You owned the company for years. I just bought it. Is it fair for me to pay for your $10 million mishap when I paid you $20 million for the company? Right? So you talk about risk allocation and whose responsibility a certain item should be. So that's what you're really trying to get at with the reps and warranties, allocating risk.
And it gives you a type of a vehicle for recourse of action.
That's right. That's right. And that vehicle is typically indemnification. And so, there are a number of different ways that you can structure that. And many private deals, the buyer will hold back some of the purchase price. So say, for example, I wanted to acquire your company for $20 million. Well, I may give you, let's say, $18 million up front. And I may hold back $2 million for a period of a year or 2 years or 18 months. And that escrow fund, if you will, would be the way that I could get recourse if you breach one of those reps and warranties. So, we may have a provision or an escrow agreement that says, I owe you $20 million. We all understand that. But if you breach one of these reps, I can recover through this escrow account. If I never have to use it and 2 years goes by and you didn't breach any of those reps, then you get paid out the remainder of that money. But you'll often see a holdback or an escrow holdback for indemnification, just so a buyer can be comforted that, you're not walking away with money and leaving me some liabilities behind that I didn't know about.
Okay, so we're at the point where we're about to close the deal. Okay, are there any other special considerations that come into play at this point?
So closing the deal, and again, there's some differences between public company and private company deals, and even some differences between different private company deals. So it really depends on if there's a simultaneous sign and close versus.
Wait a minute, what do you mean by that? Simultaneous sign and close. What is that?
So that just means, again, we'll go back to your company.
Yeah.
I'm buying your company. We enter into a purchase agreement. The day we sign off on that purchase agreement, the deal is done, right? We signed it, we inked it. The ink hasn't even dried yet, but the deal is done. When we sign that, I owe you your money. I have to wire it to you. And then whatever post-closing obligations we have to each other begin at that moment. But after that, I own the company. So with the signing and then a delayed closing, there are typically certain conditions that need to be satisfied, and that's why someone won't sign and close simultaneously. I'll give you an example. Let's just say that you are a highly regulated industry, and some regulatory body needs to sign off on our combination, right? And so we may have to wait 5 months for that. So we sign the agreement, we wait on consents that we need. Once we get those consents, then we're free to close, and then we move on and we close. So that's the difference between a simultaneous sign and close and a signing and then a delayed closing.
Okay, so I interrupted you. Go on with closing conditions.
So closing conditions, again, these are just certain actions that need to happen before the parties can move on towards closing. We just mentioned one of them could be regulatory consents.
Yeah.
Another could be third-party consents. Again, we'll use the example of the contracts that you have to sell your widgets. Will those parties that are, make up your revenue stream, will they agree to this transaction? It may be that they don't want to do business with Kevin's widgets. Maybe they heard something about Kevin's widgets that's not aligned with their business model, and they may not consent. So, we may condition this on we need your customers. And if your customers won't come along, then we get to back out of the deal. And there are a number of different closing conditions. It really depends on the transaction and the specific facts. But one thing's for sure, a seller doesn't want many closing conditions because that gives a buyer an opportunity to pull out. A seller wants deal certainty. They may want, one or two closing conditions and let's move forward to closing. A buyer is more comforted by closing conditions because they can say, okay, if this doesn't go exactly like I planned it, I can pull out. And so again, that's an oversimplification, but that's what we're talking about when we talk closing conditions.
Yeah, I would suppose a buyer would want to be protected at all costs because you don't want to make a major purchase like this and find out you're stepping in quicksand.
Well, that's right. And deal certainty is super important for the seller. So, seller's counsel will fight really hard to make sure there are minimal closing conditions. Deal certainty is number one. They've done all this work. They've disrupted their business to an extent. And so there's a lot.
It costs money.
They've paid legal counsel. They've paid accountants. They've diverted their management's attention from running the business. And so for that to fall out or not come to fruition, it can be damaging for a seller.
Got it. Okay, so Kevin, tell them a little bit about your practice again. We're almost at the end of this segment.
So my practice is corporate and financial institutions, primarily mergers and acquisitions, but we do also a lot of corporate governance work, a lot of restructuring work, and literally anything related to business transactions is under our corporate umbrella. It's pretty broad. And we also counsel banks and financial institutions such as fintech companies. There's a lot of overlap between
fintech companies. What's a fintech company? I know we're at the end of this segment, but you got me interested there.
Fancy name, it's kind of a combination of financing or financial institutions and technology.
Okay.
Right. So a lot
Used a fancy term there.
Yeah, and a lot of banks are banks and other financial institutions are actually starting to contract with fintech providers for value-added services they can provide to their customer base. So technology is kind of the monster that drives our world right now.
Right.
And so you'll see a lot more fintech companies coming up over the next few years and decades for sure.
Awesome. We're at the end of this segment. My name is James Lewis. You are listening to Lewis on the Law. All my old shows are archived on my website. If you have a topic that you want to hear, go ahead and contact me at 404-610-0075, and I will bring on an attorney who actually knows something about your topic, and we'll talk about it on air. You can also contact me on the last page of my website at jameslewislegal.com. The contact page is at the end. You can also email me at james@jameslewislegal.com. When we get back, we're going to kind of wrap where we've been because we've thrown a lot at you, and we're going to finish out how you close this deal. You are listening to Lewis on the Law. My name is James Lewis, and I am bringing you empowering legal information each and every single week. And once again, I want to remind you guys that we don't actually give out legal advice here on the show. We do give you information to help you make an informed decision. It may help you decide what type of issues you need to preserve, what type of an attorney you're looking for, whether you have a case or not. That's what this show is designed to do. If you have a serious legal issue, go ahead and contract with an attorney. You can always find one through my website at jameslewislegal.com. Just go through my podcasts, my videos, and I allow all the attorneys to give you some contact information. You can always contact me, and I will help you find an attorney. I may be able to help you with your legal issue if you're in property. If it's a property issue, I may be able to help you. If not, just go ahead and give me a call, 404-610-0075. You can drop me an email at james@jameslewislegal.com, or you can just go to my contact page and hit me up there. Kevin, we're having a great discussion here. Are there any other closing considerations, post-closing considerations here?
Well, from a business person's perspective, sure, there are a number of them from a legal perspective, but we'll talk about what's interesting to the business owners. Mm-hmm. And so one of the things that is super important is the integration, right? Mm-hmm. So if I buy your company, then how do we seamlessly, combine these two companies? Mm-hmm. If that's our goal, assuming that's our goal, how do we integrate your products with ours seamlessly where we don't disrupt our business? Where do we warehouse your stuff, right? Mm-hmm. Do we have enough warehouse space to buy all your widgets and keep them on site with us? Do we need your space? Do we continue to rent the space that you have now, or do we break the lease because we have enough space? Who's going to run the company? Mm-hmm. You may be the expert in your widgets, so perhaps we enter into a consulting agreement with you, or we bring you on as a vice president. So there are a number of different issues. That sounds like
a great deal. You pay me, and
and then I pay you some more. Right?
I know that's a great deal. I need to get into widgets. That's what I've missed.
Well, and then there are a number of ways that you could structure that. It could be an employment agreement. It could be a consulting agreement. The companies could also enter into what we commonly call a transition services agreement. Mm-hmm. Because you are the expert in this particular, piece of business and, perhaps the infrastructure that comes with it, we're going to need you for a period of time. Could be 18 months, could be 6 months, could be 2 years to help us integrate. And you're right, we would probably be paying you, although that's not always the case. We probably will be paying you again.
Yeah, so maybe like written into the sale contract, right?
So maybe you get the cash out twice, but that's certainly not always the case.
Yeah. Okay, so we've gone through a lot of stuff. It's really dense, the material that we've gone through. Can we just kind of get a timeline and some milestones here? Let's go through those.
Sure. So as far as the timeline, I think the typical process would be somewhere between 3 and 6 months. Mm-hmm. Now, I've had deals that have lasted for much longer than that, and some for much shorter than that. But I think typically it's 3 to 6 months. And as far as milestones, again, we'll just recap briefly. We talked about pre-planning and preparing yourself for the process, whether that's hiring advisors, doing internal corporate and business housekeeping. Then we talked about entering into a letter of intent after the parties have exchanged a certain amount of information about each other, and they agree to agree, if you will. It's agreement in principle to negotiate in good faith. Then the bulk of the due diligence starts. The buyer is really digging in to see if there are any landmines or any risks that they don't know about. And then after that, they actually, or oftentimes at the same time that they're doing the diligence, they're negotiating the primary transaction documents, the purchase agreement, the escrow agreement, if there is one, if there are any employment agreements, like the example that we just used. And then once the agreement is in good shape and both parties are signed off on the form of the agreement, then you actually sign it. And then we talked about this earlier as well. If it's a smaller private company deal, there are no, large consents that need to happen, then they can sign it and close it and the deal's done that day. With a larger company or someone that's highly regulated, or maybe there are a lot of different third parties that we need consents from, then there may be a signing and then closing way down the line. But that's typically your timeline. And then we just discussed certain post-closing things like integration as well that could drag it out a little longer, but that's typically your timeline.
Okay, so let's talk about the type of transactions and the documents that correlate to those transactions.
So again, there are three primary types of transactions in M&A. There's your equity purchase. Most people will hear this described as a stock purchase because a lot of people are familiar with corporations. So if it's a corporation, it's a stock purchase. If it's an LLC, it is a LLC membership interest purchase. The other type is an asset purchase, where instead of buying your stock or your equity from you, I buy your widgets, I buy your contracts. Then there's also a merger agreement, a merger structure where the two companies combine. And so the purchase agreements would mirror that type of transaction. And one thing I'd be remiss if I didn't mention this. Many times the transaction structure is driven by tax considerations. We have a rule, in the M&A practice, ask the tax guys first, right?
Okay.
We would never decide. We would not decide on a transaction structure without talking to our tax colleagues, because we would not want to do anything that could harm our client from a tax perspective. So maybe one transaction saves them a lot of money, either immediately or down the line with respect to tax considerations. So we always start with our tax advisors first.
Okay, that's a really good point. I mean, can we get into some of these tax considerations, or maybe not?
Well, full disclosure, I'm certainly not a tax
your
lawyer.
area, huh? Yeah.
Well, I'll give you one example.
Okay.
Right. So if you buy a company via a stock sale and you're a buyer, then and I'm sure you've had tax experts probably on your show, then the basis that you take in the assets that the company has is it's a transfer basis. It's the basis that the company already had. And, just to back up a step, the basis is just kind of the internal value of that asset. And so if someone bought an asset for $1 million and they're entitled to depreciate it over time, then when I buy your company, I am buying it, and that my basis is that depreciated amount. Yeah. So I can only depreciate it down, from there. When you buy something via an asset deal, you get to step up, as we call the basis. Your basis will be what you paid for the assets. So your basis will go up, and now you can depreciate. There's more depreciation on the back end. So that's one of the tax considerations.
And that's a huge tax consideration.
Absolutely. So most sellers, would prefer a stock sale, and many times buyers will prefer an asset sale. And there's some mechanisms. There's something called a 330H10 election where you can have an equity sale treated as an asset sale, and many times it can make both parties happy with certain considerations. But tax is where we always start, because we would not want to do something that would be harmful to our client from a tax perspective.
And that's a big consideration. Okay, so let's talk about the representations and warranties that can be made during these deals.
Right. So to recap on that, the reps and warranties are really disclosure and risk shifting tools. Okay. Disclosure, on the disclosure front, the reps and warranties could really help you supplement your due diligence. So for example, I may have a rep and warranty that says, other than as set forth on Schedule 1, you have no intellectual property that you use that's owned by anyone else, right? So even if we didn't turn anything like that up during our due diligence, you would have to disclose anything that meets that description. And so it may help us ferret out something that we never saw before.
Exactly.
Right.
Okay.
And then on the other side of risk shifting, we use the environmental example. If I'm a buyer, and something happened 2 years ago, you had a big hazardous waste spill nobody knows about. We buy the company. In 5 years from now, the EPA comes after us in the tune of $10 million. Ouch, right? Who should pay for that? So if I'm a buyer, I would negotiate a rep and warranty that says, for the past, let's call it 3 years, you have not had any of these environmental violations. And for a period of 2 years following closing, if we find out that you did, then you owe us for that. So it's really risk shifting, and it's about disclosure when it comes to reps and warranties.
And that indemnifies basically the buyer.
That's right. The buyer, through the indemnification procedures that are set forth in the purchase agreement, would have recourse against the seller. And the indemnification provisions would very carefully lay out the scope, when you're entitled to recover, how much you're entitled to recover. Are there any limitations? Perhaps they negotiate a deductible. We call it a basket in M&A, where the seller may say, okay, I agree that you can come after me for this, but not until the total amount of the losses is over $500,000. Kind of like a deductible in a car insurance policy, right?
Exactly.
So there are a number of different limitations that the party can negotiate procedurally in the indemnification provisions. But at its core, you're exactly right. You breached a rep. I have an indemnification provision that allows me to go after you in a more detailed and clarified manner than just a common law breach of contract.
Gotcha. Okay, so we are at the end of our show. It has been an awesome, fun, and exciting, and we threw a lot of information out there. So that recap was really good. I'd like to thank you, Attorney Kevin Coleman with Troutman Sanders. He's an associate in corporate practice, or he's in the associate in corporate practice and banking.
Yep, and I would call it financial institutions.
Financial institutions.
We represent banks, and banks, is kind of our Venn diagram. Banks are financial institutions.
Yeah, but there's so much more.
There's so much more. Again, there's fintech. There are a lot of different vendors.
And that's a new term for me. I was like, I didn't catch the fintech.
Right.
I haven't heard that
one.
before.
So we service.
But I like it.
We service the larger financial institutions sector or industry, and not just narrowly the banks. And there's a lot of overlap between our corporate practice and our financial institutions practice, because a lot of times they have the same needs.
Excellent. Okay, we've had an awesome show. Next week, we're going to get into asylum law. That's right. We're going to start to touch on immigration. We have a couple of shows coming on in the next couple of months on immigration. I'd like to thank you once again, Kevin, for being on with me. You're listening to Lewis on the Law. And once again, I'd like to thank the guys who make the magic happen. The maestro of music over there, Sam Davis, and the Vilnius Viper of video over there, Anthony Cook, making it all happen. Thanks, guys. I'll see you next week.